I can just speak about the type of work that I'm doing, which is trending at the moment, or what's really happening in dental practices, that will probably raise a lot of the points that people are dealing with, because I tend to find everybody's dealing with the same issues. And I think that might be quite a good question to get started.
Well, I think now we're kind of at 7, and I know you've got to be somewhere else for 8. So, you know, let's sort of get going. People, I think, will be joining as we go along. So, you know, we'll kind of add people as and when. So I think I'll just sort of, you know, when we say, well, thank you, Sarah, for giving up your time and welcome. What will be really useful is maybe if you just let people know, you know, as you say, you know, who you are, what you do. I mean, they should know, having read your bio, but possibly if you could just update people. And then, as you said, if you could just start maybe with what you're seeing at the moment and things that we should be aware of. I've had a few questions sent to me for people who can't be here, and I'm sure that some of the you know, attendees would be have maybe got some questions they'd like to ask you. So the floor is yours.
Oh, thank you. Yeah, so I'm Sarah Buxton, and I'm a HR and employment solicitor, and I'm also a director of FTA Law. So we're based just outside Leeds, but we act for dental practice owners and managers all over England and Wales in all aspects of buying, selling and running a dental practice. And my job is to help dental practice owners and managers on the day-to-day team management and drafting contracts, all the way through to helping with disputes. And it's been a year of furlough, COVID vaccinations, but I was just saying just before people started to join us, it's been really interesting because at the moment there's definitely a trend in that the type of work is changing to more dispute-led work, because there seems to be a lot of employment tribunal disputes happening in dental practices. I've acted in the dental industry for about 11 years now, and what I've found is that it tends to peak and trough in terms of employment tribunal claims, and it's definitely peaking at the moment, because I think either because it's been so fast moving over the last year, either employers and managers have got it wrong. I think there's a lot of aggrieved people out there who are frustrated and quite angry, so they start looking for tribunal claims, and I think that is on the rise. There's a lot of whistleblowing which is happening in dental practices. So the trend at the moment is that what I'm finding is that there's more tribunal work, more dispute work than what there has been previously.
And what would you say would be the best way to try and avoid getting to that point of tribunal?
Yeah, I think it's really important to, and I'm going to say this, but take advice, because it is fast moving and it's changed so much that when you have 101 other things to worry about in practice, you can't be expected to understand how the employment legislation has changed, or you may not even know it's changed, as it's my job to know that it's changed. I have liability for the advice that I provide. So I think it's important that if you're going to do something which is maybe not an everyday management situation, like having a team meeting or one-to-ones, but maybe you are looking at bringing somebody's employment to an end, or you feel as though you have somebody in practice where it's got to the point where you have to deal with their sickness absence, and you need, I'd say, you need to take advice to make sure what you're doing is up to date. It's been quite interesting on a lot of the social media forums, because I think they've been great for giving people comfort and support over the last 9 months. And I think people have looked a lot more to social media because we're not seeing people. But the worry is that the advice on there isn't always correct. So I've seen things like people put links from Australia on there. I've seen people breaching confidences and confidentiality, talking about people who you can easily identify and know who that is within the team. So I'm dealing quite a lot with that, where the employee has said, there's one incident where the practice manager has gone onto a forum and spoken about this individual being pregnant, and it's very early days, and she's told that practice manager in confidence, and she feels as though there's been a breach of confidentiality because she hadn't even had the opportunity to tell people who she wanted to tell. So we've got to be so careful with these forums, and then what's happening is if people are relying on that advice, they're getting it wrong, and then we end up in a tribunal. So I think just make sure that you put yourself in the best position possible by taking advice.
So Sarah, could I ask, please, there is a lot of chat on forums as well, as you alluded to with the pregnancy bit at the moment, and COVID is incredibly confusing, and the Royal College of Obstetricians, Gynecology and the Midwives are kind of a little bit at odds sometimes. Could you give any advice to us and members about how we should act and go forward for our pregnant staff, to obviously for their safeguarding and to make sure that we're behaving in the right manner?
Yeah, I've always said right from the outset that when it comes to somebody who is pregnant or has, and I don't mean to put these people in the same category, but has an underlying health condition, or there's something where we don't actually know the consequences yet of COVID and what may happen. And so I've always said there really should be a belt and braces approach. And what that means is that if you have somebody who is pregnant, I think it's sensible that up until that 28-week mark, as long as you've got PPE and you've done your risk assessment and they've got no underlying health conditions, then they can go ahead and see patients. But I think after that point, until we have a lot more guidance and we know the consequences, I'm saying I think you need to consider a non-patient facing role. And if you can't provide that and they can't work from home, then it may result in a suspension from work, or it may be a possibility that they start their maternity leave early as well. So there are lots of options. And I know that...
I think the suspension from work thing, if we're just clear for everybody, that's a suspension that the owner would pay on full pay, is that right?
It is.
Yeah.
Yeah.
Thank you very much. Yeah.
It is, yeah. That's because you may think, well, commercially, I don't want to do that. The guidance, like you say, is contradictory. And I've got an employee who wants to work. I'm happy for them to work. But I think it's still early days, as in we don't know the consequences of what's going, if something happens in practice and you're under a duty to provide a health, a place of work which is in accordance with the health and safety regs. So because it's so much of an unknown situation, my advice is really, I think we do have to be very careful with individuals who are pregnant or have an underlying health issue.
So would you say if that you put them on suspension on full pay if you deemed it unsafe for them to stay in practice, what would stop you from furloughing them?
Well, if you're up until this point, the furlough guidance has changed on numerous occasions. So for a fully private practice, you were okay to use the furlough scheme in those circumstances, up until the third time that it changed from October onwards, because the business had to be affected by COVID to rely on the furlough scheme. And then it was only in January where they changed the guidance again and said that if it was childcare related or maternity or pregnancy, you could then use the furlough. So the guidance was very slow, but up until I think it was the 12th of January, they changed it again, and in those circumstances you could use the furlough scheme. But over the last year it's changed, that there's been certain points where you haven't been able to use the scheme. And that's because the scheme was brought in quite quickly and wasn't quite well thought out, and the law lagged behind. So suspension on full pay was something that we always advised, even if you couldn't use furlough. And as of January this year, you could.
But you said if you're fully private, so is that different if you're mixed or NHS?
Again, it was up until January, because the NHS guidance was said that you basically had to separate your practice in proportions, and if they fell under the private proportion, then you could use furlough, and if they fell under the NHS, you couldn't, because to claim the NHS funds, you had to keep paying your NHS staff in the same way that you've always paid them. And then the guidance said that you shouldn't have a windfall out of these circumstances as well. So if you were taking the full NHS payment and you ended up having more, ended up more better off because you'd used furlough, that also went against the NHS guidance. Now that they're back to UDA targets, the conditions have been removed, so as of January, and I don't see anywhere in the guidance where you will be prevented from using furlough, because if you don't hit your target, you're going to get clawback, so you're not having a chance of double recovery. That's what the NHS were worried about. So you just had to be very careful when trying to use the furlough scheme if you were in NHS practice or are.
Excellent, thank you. So I have some more questions, but I'd just like to ask if anybody else who's on the call would like at this point to ask a question. So there is a question coming in, I think, from Shamik. So do you want to unmute yourself, Sham, and ask your question?
Hi, Sarah. Can you hear me? Thanks for doing this. That's really great. Same question. What about self-employed associates who are pregnant? Can they just carry on working till they're 28 weeks? Or do we have to tell them that, no, actually, you can't see patients?
So up until 28 weeks, they think the risk is quite low. So they can see patients in those circumstances. Once they get to 28 weeks, I think you would be, under your risk assessment, be saying to a self-employed member of staff, so whether they're an associate dentist, therapist, hygienist, you would be saying to them, under my risk assessment, at this point, you can't continue. And then it would depend on the clauses in the associate agreement, but more than likely, you would you can suspend them under an associate agreement, and they would put a locum in place. So you're still under a duty for self-employed staff to ensure that their health and safety is adhered to, and it's still the same really, whether they're self-employed or employed.
So, I mean, yeah, because I think we have a member of staff who wants to come back, who wants to just finish off some cases, and we're trying to make sure that they're totally non-AGP. But yeah, she's quite keen on just coming back 1 or 2 days just to finish, and she's just gone past 28 weeks. Yeah. So we're just trying to debate what to do.
Well, I think in those circumstances, you've got to weigh up your risk. So as I said, I'm advising from a belt and braces approach, because I think that because we don't know the consequences of COVID and pregnancy properly, and this is why everybody keeps changing their advice all the time, is that I think we're, if she's got a couple of cases, the risk is lower than somebody who's coming in and working full time.
Correct. Yeah.
So you know, if it's she's just gone 28 weeks and she's got a couple of cases to finish off, commercially, it's probably worth to finish them off because the risk is quite low. If you were saying to me she needs to come in 5 days a week and do all these cases, and actually she's nearly 30 weeks, the advice may be different because I think the risk is higher. Does that make sense?
Yeah, makes sense. Yeah, I agree. Yeah, thanks.
No problem.
Cool. Chris, did you want to ask a question about vaccine?
Yeah, so another really hot topic at the moment, Sarah, is vaccines.
Yeah.
And people having them or being made to have them or feeling uncomfortable having them. Yeah. So where do we stand from an employer point of view, please, if a team member will not refuses to have the vaccine, and how do you stand from the point of view of a employee if your employer is saying you have to have a vaccine?
Okay, well, in this country, we have a piece of legislation that prevents vaccinations from being mandatory. And yes, I appreciate that in dentistry, there are certain vaccinations which the GDC do state are mandatory to be registered as a clinical professional. And I find that then, because you know when we have these vaccinations that you can't work without, it's quite, I find that a lot of the dental industry are very pro vaccination, and they would like this to be mandatory within their practice because they see this as something where they are looking after their staff and their patients. So I totally understand where people are coming from, but until the GDC make it mandatory, it is difficult for you as an employer to mandate that an individual has to be vaccinated to be part of the team. And if they have been with you for more than 2 years and you try and bring in this policy or make it contractual, I believe that they would have a very good constructive dismissal claim if you went down that route. And what that means is that if you said to them, you can't be part of the team without this vaccination, they'd be able to resign, or they would say that you dismissed them, and they would have an unfair dismissal claim in the tribunal, and they can be awarded up to £86,000. So we don't really want to go down that route. Also, we've got issues with discrimination. Lots of people did have issues with certain vaccinations because there was stuff in the news about maybe it affects fertility. Some people might have religious reasons for why they don't want it, because we don't know if a belief in not being vaccinated falls under the protected characteristics, because we have religion and belief covers a huge area, to the extent that it covers political opinion, vegetarianism. So it wouldn't surprise me if belief also covered a belief in not being vaccinated or in this particular circumstance. So I think we've got all sorts of discrimination that we could get ourselves into issues with. So the best advice is to try and engage the team by explaining that you would like them to have it, making sure that you provide them with as much information out there as possible. There's some really good leaflets about the different vaccinations and what's truth and what isn't, to try and explain what, and that's the only advice that I can give, because you can't force anyone in this country to have a vaccination, and until the GDC turn around and make it mandatory, I don't think that a practice owner would be able to argue that it would be proportionate and reasonable for them to demand that their team members have this vaccination.
Thank you for that. We've got a couple more questions that have come up in the chat. So I don't know if Liz wants to unmute, or if you want me to ask the question. Do you want to unmute yourself and ask Sarah your question about?
Hello, Sarah. Thank you.
Hi.
Introduction. Thank you so much for this evening. It's really useful. Just a quick question about mental health illness, especially during the last year. Just inquiring about associates who has had some time off due to mental health and had doctor's certificates to prove for the time requested to be off. Then what is the protection for associates if their contracts to be terminated?
I suppose, first of all, it depends on the reason for the termination. So
this would be for the lack of the breach of contract for the amount of clinical days, non-clinical days.
Okay. So in those circumstances, associates, so self-employed staff are still covered by the protected characteristics, so the discrimination legislation. Yeah. And one of those protected characteristics is disability, and disability covers physical and mental illness.
Yes.
So the definition of a disability is something where it affects their day-to-day activity and it's likely to last 12 months or more. Yeah. And if you can prove that that is the case in respect of this illness, whether it's a physical illness or a mental health illness, and as a result of that illness, their contract is terminated, that would be a straightforward discrimination claim because their contract has been terminated and they suffered a detriment due to the fact that they have a disability. Okay. And what would actually have to happen in those circumstances is that the person who engages them, so the practice owner, would have to show that before they terminated that contract, they did everything to assist and help that self-employed member of staff, because they're under a duty to make adjustments and to do risk assessments and to encourage them and get them back into work. Yeah. And nobody's saying that you have to keep somebody indefinite, whether they're self-employed or an employee. If they are not attending work, it will get to a point where the courts will look at something and say, well, actually, that was probably proportionate, as in you can't be expected to keep somebody for so long. You're a small business, it's going to cost you, it's going to affect morale, and the courts see that. But before you get to that point, you have to have done everything to help that individual. So there is a lot of protection out there for self-employed staff, which people don't always realise, because they think, oh, they're self-employed, they've got no rights, because they do. What they don't have is certainty in respect of they may have their contract brought to an end at any point, as long as the practice has got good, sound business reasons for doing that. They're still protected under the discrimination legislation. So if they have a protected characteristic, and they should be listed in an equality and diversity policy, one of them being, in this circumstance, possibly a disability, that there will be a claim there if it's not justified.
Okay. What would you deem reasonable support and adjustments to be made? Because in this particular case, it was requested to have reduced hours, which was granted. This associate worked 5 days a week, was granted to work 4 days a week, but still required the odd occasion of time off and extensive, maybe a week or 2 weeks at a time as well, but kept coming back and forwards and trying to get back into work, but just not quite managing. And then towards the end asked if the contract could be reviewed to change the hours from full-time to part-time, and that was declined.
Okay. So I think it's important that if, and I keep coming back to, if this mental illness falls under the definition of a disability, and I can't give you a list, for example, of illnesses. There are some which illnesses are definitely disabilities. So cancer, for example, that's classed as disability. Yeah. Mental illness is relatively new in the employment world. It's only in the last 10, 15, 20 years where we've been advising on it. And what happens is, to decide whether something falls under the definition of a disability, it's not for myself or a practice owner to decide. It would actually be a medical consultant, so occupational health or a GP. They're the best people to say. And they are also the best people to say what reasonable adjustments are required. Okay. So this happens a lot where a self-employed individual or an employee may say, I require part-time hours. Well, actually, has a medical practitioner said that you require part-time hours? Yeah. Because it may be the case that actually an occupational health or a GP would say, there's no reason why you can't work full-time, but you need more breaks. That might be a reasonable adjustment. So, okay. Yeah, so it's really down to somebody with some medical background to be able to say what was the best in those circumstances. Okay. But also with making adjustments, you don't always have to make them if you can't make them. So if you've got a justifiable reason as to why you could not make those adjustments, and one of the things that we do have in the dental profession is continuity of patient care, which is always the top. Cool. So if you can't provide patient care in the right way because of these adjustments, that probably would be why it would be justified that you couldn't do that for that individual.
Sure. Thank you so much. That's very, very helpful. Appreciate it.
Okay, good.
Thank you, Sarah. I've got another question here. Somebody said, how, I need to actually get the question written up. I'll just draw it up here. It's about IR35 and how would you say the situation is versus employed? So it's sort of, how is IR35 likely to affect self-employed dentists and therefore practice owners? Because obviously, traditionally, self-employed associates have been sort of protected from being considered employed. Mm-hmm. And there's, for as long as I can remember, people have been talking about HMRC wanting to change that. But, you know, how would you say is the best way to protect both the self-employed and the practice owner from future sort of tax issues on the basis that people could say, well, actually, they cover employment, not self-employment?
Yeah, I mean, the best way that you can protect yourself is contracts, making sure that you have the right contract drafted. And what I find is that not only the contract's the starting point, so you must follow what's in that contract and ensure that that contract isn't a sham. Sometimes what I find is that people take template contracts from various places and maybe take out bits that they don't understand or you know, agree with their associates that they'll take out, and they may be taking out things that I would deem as being a self-employed indicator. And the more indicators you have in that contract of self-employed status benefits both parties, because the likelihood is that you'll be found to be self-employed more than employed. In respect of what those self-employed indicators are, you're looking at a big one that we look at all the time in the Employment Tribunal arena and in the tax tribunal is locum. So putting a locum in place, because as an employee, you can't send somebody else in to do your job. that is definitely a huge indicator of self-employed status. And sometimes what I find is people take that out because they don't like the idea of having a locum in place, and they feel as though they're losing control if the associate does put a locum in place. And of course, for hygienists and therapists, it's very rare that that happens. So we need to be creative in respect of that locum clause, and maybe look at things like, is a locum deemed to be another associate in the practice who steps into the shoes? That can be something which we can do if you're worried about it. I've seen people take out the license fee. So the license fee, because what actually happens in a self-employed agreement is that the associate or the hygienist or therapist should be saying, I'm paying you a sum for the use of your equipment, your chair, your surgery, your dental nurse, the reception staff. And some people take that out and either pay a flat hourly rate, or they will say to, they'll put something in like, the associate will be paid 40% of the fees that they gross, but that's different, and the terminology is wrong, and that's not a self-employed indicator. So as much as possible, you must look at the contracts and ensure that there's as many indicators as possible in there. And I think where the IR35 is definitely is focusing individuals who, and this does happen in the industry, not so much because of the issues with NHS pensions, but in private practice, you do find that some associates set themselves up as limited companies, and the practice owner pays the limited company, and then the limited company will either pay the associate, usually by dividends, because that's the most tax efficient way of doing it. And I think it's going to be that relationship between this limited company and this associate down here that HMRC are worried about. And I think because all they're really doing in those circumstances is slotting in this limited company to get away with paying the right tax, or the correct tax, or looking at tax savings, and that's what HMRC don't like. So I think in those circumstances, again, we need to ensure that as a practice owner or manager, we've put the correct contract in place, so that if that is ever looked at, you are protected, because there are clauses in the contract that you can put in, such as tax indemnity clauses. And I would always, if I act for associates, I always say there's no point trying to negotiate that out, because any practice owner who's taking advice will say, I'm having it in, or I don't engage you. That tends to be how it goes. So you must ensure that you have tax indemnity clauses in your agreements.
Do you think that we're heading towards the employed associate over the self-employed associate?
Well, like you said, Carol, I think it's one of those things that's been around for years, and it's always talked about. And I think if we hadn't have had the COVID pandemic, I think we would be in a different situation with it, because before COVID, which seems like a long time ago now, there was a case that dealt with it was the Uber taxi drivers. And what they did is the Uber said, you're not workers, you're not employees, you're self-employed, you're not getting paid any holiday or sick pay. And they weren't very happy. It went all the way to the appeal court, and they were found to be workers, and Uber had to pay back holiday pay and sick pay that they hadn't been paying their drivers. But it's quite interesting here, because the reason why the Uber drivers were found to be workers is because they had individual licenses where they could not send somebody else in to do their job, which is the locum clause that the dental industry have. And then because of that, a report was issued where they looked at the 3 different types of employment status and how it was all a bit of a mess. And they were looking at maybe just making the law a little bit neater. in respect of what is self-employed and what isn't. So I think if they ever turn their attention back to that, and I think the government have got a lot on their plate, and I think we're years off before they look back at it, I think there will be a shift, because I think you will become more at risk of being found to be an employed member of staff as a self-employed person in dental practice. The people that worry me the most are hygienists and therapists, because the relationship with hygienists and therapists is not the same. They tend to be paid hourly rates. They don't have as much risk as associates. They don't tend to locum. So there's lots of indicators which show that they're employed rather than self-employed, and I think that's the group of people we need to be careful with and look at carefully.
Oh, I certainly agree there. Mine are certainly employed. So I've got another question here about contracts. So a lot of practices are kind of busy but quite cautious about employing permanent staff members, because it's a little bit of a different time to normal. So is it possible to offer fixed term rolling contracts so that it would be easier sort of to terminate as and when there isn't that work, and therefore avoid a redundancy payment?
You can give a fixed contract, and it's so important that you put it in writing and make it, and it's very important that you manage the situation, that they understand that this is for a fixed term or a rolling term that may expire on X date. And I think managing the person's expectations is really important, and then putting it in writing, making sure it's in a contract. Even if you have a fixed term contract and they get to the 2-year point, you will still have to make a redundancy pay. It's still a redundancy situation. All you're doing is preventing yourself from having to go through a procedure to make them redundant, because it's already on the cards, but they will still be due their statutory redundancy pay. But also, it's quite important to know that you can't continue to have this rolling contract, and especially past 2 years, because it will just be deemed to be a permanent contract like any other employed member of staff. And unless you have a break in the service, which has to be at least 4 weeks, their employment will continue. So I've heard people say, oh, well, I've taken people on for 3 months, and then I've said, oh, I don't need you for a week or 2, and then I've taken them back on and it starts all over again. Well, actually, in those circumstances, their employment will continue because you haven't had a 4-week break. So you have got to be careful using them. If you take someone on a 6-month contract, a 12-month contract, you won't have to make any statutory redundancy pay, and you would want the contract drafted so it automatically expired. But once you start getting towards 2 years, it's deemed to be a normal contract, and you'd have to pay statutory redundancy.
Brilliant, thank you. So I have some more questions from other people, but does anybody on the call have a question that they'd like to ask Sarah before we kind of carry on? Because I don't want to, if someone's on the call, I'd like to give you opportunity to ask. Don't be shy. No? Okay. Okay, well, I'll carry on then in my list that people have sent to me. So what is the best way to manage team members who are going to want to go away on holiday, or they need to go and see a family member in another country, and they have to self-isolate when they come back? Would that self-isolation, should that be taken as holiday? Should that be taken as statutory sick pay? How should that be managed if they know they're going to have to self-isolate? Do they have to take the whole period as holiday, or what's the best way to manage that?
In those circumstances, I think as a manager, I would be saying to them, you have to isolate when you come back, and therefore it should be taken as holiday. The guidance does distinguish slightly between quarantine, coming back from a holiday, and people who have to self-isolate because they've got symptoms where SSP would apply, and it's a little bit torn as to whether you could claim the SSP for the quarantine period, but I don't think that's in the spirit of what it was drafted for. And I think actually what they want to do is put people off going and quarantining. So I think you would have to have a conversation with them where you make it very clear that they're going to use a lot of holiday or take unpaid leave, because it's you as the practice owner who's having to claim back those funds. If you said it was, for example, SSP, and then it wasn't agreed with. And I do think we do have to be careful with things like SSP and furlough, because it's cost billions of pounds to date, and HMRC have made it very clear that they want you to keep all paperwork and all agreements with staff with flexi furlough and all details of their hours that they've worked for at least 5 years, because they are going to come back and investigate. So again, I would say, especially in this industry, where it's so important being trustworthy and you're highly regulated, that you do have to err on the side of caution with making claims to these funds. They just released the other day the list of people that had claimed furlough in December. So they're doing that to try and put people off claiming furlough when it's not needed, and so that employees know if their employer is claiming furlough, which I think is interesting, because HMRC are almost encouraging employees to whistleblow if their employer's on there, and yet they're not aware of anybody actually on furlough leave. So it's interesting to have a bit of a nosy on that spreadsheet, see who's claiming it.
Okay, so thank you. So here's a slightly different, but slightly back to vaccines. What's the best answer to tell patients if they ask if the team have been vaccinated? Because obviously, do you need written consent from the team? And what if not all the team members for various reasons have been vaccinated? So what is the best way to address that with patients without ending up breaching confidentiality?
Well, I don't think you can give that information to a patient, and I think it's about being understanding and saying to them, I understand your concerns. However, I am prevented from providing that information to you. But what I can confirm to you is that we've done our risk assessments. All staff are in full PPE, and we've got our new procedures in place to ensure that the spread of any illness is limited, and you just need to almost divert them away from the question and just look at the positives of what you've done to protect your patients going forward.
Yeah, okay, that's fair enough. And then this is the last question I've been sent in. This is from a young dentist, and their question was, what is your #1 piece of advice for dentists who have finished their foundation year and have just started as a self-employed associate?
My piece of advice to associates, and I do a lot of speaking for people for associates and their vocational training and things, and I always say to them, I know it's exciting getting an associateship, and it may have been quite hard to get that associateship, and it's your first job, and it can also be quite daunting, but don't sign something that you do not understand. So when you get that new associate agreement, before you sign up to it, read it, and if there's something that you don't understand, take advice or chat it through with the practice owner or manager so that you do understand it, because I come across lots of associates who don't realise what they're signing. One in particular who had signed an agreement where the practice had said that if they left within the first 12 months, they would have to pay them a sum of £5,000 to cover training and costs. And it was one of those situations where the associate wanted to leave. And it's like, well, you can argue it's a penalty clause and you can argue that that shouldn't have been in there, but the practice owner in those circumstances have got the power because they have the money before you. So they'll withhold it from your wages. And then you're in a situation where you're trying to get that money back, which of course costs money and court proceedings and everything else. And maybe if he'd have read that at the outset, he may have said, I'm not happy with that clause, or he may have identified that that practice wasn't for him. So I think it's really important that for all associates that they understand what they're signing, even though it can be very exciting when you get your first role.
Absolutely. Brilliant. So a couple more people have joined us now, so I'm just wondering if there's anyone else before Sarah goes, because as I said, I know you've got another call at 8 o'clock.
Yeah.
So is there anyone else who'd like to ask anything at all? Because Sarah is a font of knowledge.
Thank you.
Hi, Sarah. Hello, my name's April.
Hi.
I'm actually an associate, and I'm a member of the BACD. I work in NHS mixed practice. I'm looking ahead into the next couple of years, maybe starting my own practice, and just wondered what actually all the regulations and everything, although it's daunting, they don't bother me as much as the fear around employment law, human resources, and how to manage staff and get everything right as possible. What advice would you have for me to make sure I don't fall foul of anything if I do start a practice?
Yeah, I mean, it is a big concern, and it's a concern for most practice owners, whether you're starting out new or been a practice owner for 20 years, and that's because the law changes so quickly, and people management is not easy. It's something which you learn over years of experience. But what I would say is that in those circumstances, take advice, and it can be costly if you get it wrong. So quite often you can buy an insurance package that covers you if there is a claim against you, and that sometimes can give you a little bit of comfort that you're not going to get struck with a big claim where you're having to pay out 80 odd grand because the insurance will cover it. So there's lots of support out there. We obviously, this is probably my bit to say, you know, we support lots of dental practices up and down the country with their HR and employment, and take that headache away from them. And one of the nice things is if you do have some support, CQC actually like that you know where to go for your support. They don't expect you to know everything, but they like you to have somebody on the end of the phone. And I think that's really important.
Thank you. That's really helpful. So how many hours could I expect to be on the phone with you, for example, in my first?
I mean, we try and make it as easy as possible. We have a HR and employment service where for a fixed monthly fee, we do all your HR for you. We do all your bespoke contracts. We don't give you templates, and we keep all HR files on our systems, and we try and guide you and try and be. We're not a call centre. We don't wait for you to call us. We'll tell you when you need to do something, and really try and hold your hand through the processes. And that works really well for a lot of our dental practices, really well, because it is hard. I do appreciate that. But it's just one aspect that you need to think about when buying or setting up a dental practice.
I know I'm probably being very naive, but
yeah, it can be really rewarding as well. You know, it can be rewarding if you get a good team and they're happy and you're doing everything right and it's profitable. It can be so nice to see people develop and helping them. It can be a real joy.
Yeah. Well, thank you so much for that.
Thank you.
Anyway.
Sorry, I was just going to say, Carol just beat me to it. I was just going to ask you for your contact details and how, if anyone wants to get in touch with you, what's the best way of doing it. Because I'm going to have to actually, because I think I needed a bit more information on the IR35 because I just sold to a corporate and they've just sent an email about the IR35 and that they want our personal bank details because they're not going to pay into our limited companies from April. So I need to sort of figure this out, how best to deal with it.
Yeah, more than happy to help you with that. What I would say is that also in those circumstances, do speak to your accountant because the reason why you will have a limited company is all about tax savings more than it being an employment aspect. So do speak to your accountant about the structure going forward as well. They'll be able to give you some really good information.
Brilliant, thanks.
So I have put Sarah's email address in the chat. So if anybody wants to get in touch with Sarah or her FTA Law, her contact details are there. So does anybody else want to?
Yeah, just before Sarah leaves, if I could ask a quick question, please. Not directly related to employment as such, but just while we were talking about the furlough scheme, there was, with regards to GDC, they very proudly announced that for the safety of their workers, they had put a certain percentage on furlough right in the beginning of the lockdown when the furlough scheme was initially introduced. But in the same or in a similar publication, they said, having reviewed our retention fee policies, we don't feel it needs to be reduced irrespective of dentists not working or not being able to work. From my understanding, the furlough scheme was introduced where there is a loss of income due to COVID, and they don't need those, the businesses don't need those employees working, or there would be a significant negative effect on the business. So where do GDC stand? Because their income, bearing in mind all the income is from the retention fee, and their income hasn't gone down, and they have publicly published, they've put workers on furlough scheme.
Yeah, so initially that is what they said about furlough, that to use the scheme, your business, and let's talk about the GDC as a business, had to be affected by COVID. Then they withdrew that reasoning behind it. So anybody could use furlough over the summer, basically, where they would have otherwise have used unpaid leave. So that opened it up to anybody to use furlough, even if there was work or their business wasn't affected. So in those circumstances, I think it would be hard to argue that the GDC had done something wrong using furlough. Then in October, they changed it again and said that your business had to be affected by furlough. And then they've just changed it again in January. They said also you can use it in these circumstances, for example, where there's childcare issues. So if the GDC are still using furlough scheme for some of their employees who have got childcare issues. So, for example, the school is shut and they are having to look after their children, the GDC will be within their rights to do so. So I think there's a little bit of confusion about furlough and the reasons when you can use it. So it depends why and in what circumstances they are using it for. And I think that's probably going to be quite hard information to find out at the moment.
Thank you.
Okay.
Brilliant. Well, I think Sarah, I think we'll stop there because it gives you 5 minutes to.
Thank you.
Get to Lou, have a drink. So, you know, I think that's been brilliant. Some really good advice there and good answers to some questions. So I hope everybody had some benefit, and I certainly learnt some stuff there. So thank you very much. I'm sure there'll be some people maybe getting in touch based on what you've been saying. So thank you so much. Thank you for
Thanks
your
for
time.
having me.
And you know, I'm sure I'll see you again.
Yes. Thank you. Thank you, everyone.
Thanks, Sarah. Bye.
Bye.